Hello, you are starting to view the FSA Financial Production and Financial Management Training, and this particular one is entitled Tools of Estate Planning. I would like to introduce myself. My name is Marcia Getting, and I am an Extension Family Economics Specialist with MSU Extension. I've been working in the estate planning field for a long time, and so the information that I've pulled together for you today is a result of questions that I have received at meetings, and I'll admit there's a few things in there that I think you ought to know as well. Now, I know that sometimes estate planning meetings can be a little bit boring, but what I'm trying to do with my use of wildflowers is use them as triggers where they will help you remember, I hope, some of the strategies that make estate planning a lot easier and less expensive. And if you don't like the word estate planning, think of it as legacy planning. What is it that you want to be your legacy? So here's an example of one of my flowers, and I've really developed an interest of flowers, and this particular one is called a steer's head. So that reminds me to tell you that basically my first objective is to steer you towards an awareness of Montana's plan for the transfer of your property. We know that in Montana and nationwide that 7 out of 10 folks die without writing a will. So they need to be aware of what the law is in the state where they reside. And here I'm also talking about domicile. So if you're listening to this with FSA, I've got to assume that you are a Montanan. So we want to know Montana's plan. I also want to steer you to a variety of estate planning tools. And some of these avoid probate. And as a result, you're going to save your estate and therefore your heirs additional dollars. Now these 3 flowers represent, and you know what it is, it's the bitterroot. It's the Montana state flower. And what that makes me think about is the bitterness that can result from lack of planning. Because those 7 out of 10 that I mentioned die without writing a will, we've got Montana law stepping in and saying, this is who's going to receive your property. Now, I'm going to use some illustrations. So when you see a black box like this, what it's telling you is that that particular person is deceased. So here's an example that we've got of a family. And at one time, the whole family was alive. But as we look at that family now, we see that there is a son that passed away in 1999. And then we had a daughter that passed away in 2005. The dad, the husband, passed away in 2008, and then we've got the wife that passed away in 2010. So she is the one that is the survivor. Now, I would have thought by this time she would have done some estate planning, but she didn't. So she's the last to pass away, and we see all these 4 black boxes, so that tells us those are the people that have died. But the one that we're interested in is the wife, the mother. And in this case, then, I have a red lightning bolt on the grandchild, and we will call that grandchild D. And what I want to know is what fraction, if any, will that grandchild receive because the mom died, or in this case, grandma died without writing a will. Now, you can think through some of those choices, but I'll give you 4. So what we want to know is what fraction, if any, does grandchild D receive? Now, if you were at one of my meetings, you would be a response clicker telling me which one you think is correct. So I would invite you to think in your mind there and say, I wonder if that grandchild receives nothing. Maybe 1/6, just like the rest of the grandchildren, 1/7 because there's a son that's still alive there, or 1/9. So I'll let you think about that for a second. Okay, let's see what the answer is. Well, it's 1/9. Now you might be looking at that and saying, now why would that be 1/9 for that grandchild? And we have the 2 purple grandchildren that did not receive anything, and we have a blue grandchild that received 1/3. So if your objective was to treat your grandchildren equally, that certainly was not obtained with dying and not writing a will. Now, the reason these people received that is called right of representation. Those are very important words to remember because that tells us how the property is distributed when you die without a will. Now, those of you that have written a will and you're sitting back there thinking, I don't even need to listen to this part, I'm going to say listen up. Because if you have a will, and in that will you have indicated you want your property to pass by right of representation, you're doing the same thing as the state of Montana. So how do we figure out this division? Well, the first thing we do is count the number of children that this mom and dad had. And there's 3. So that immediately tells us that the distribution is going to be 1/3. But because the son there passed away, his share passes on down to the next generation. So that is why the turquoise or the light blue grandchild receives 1/3. And then as we move to the right, we've got the son in yellow. He receives 1/3. So because he receives his 1/3, the 2 children that he has do not receive anything when grandma dies. And then we do the same thing when the wife dies there, or the grandma. We've got her 1/3 that would have gone to the daughter if she had lived, passes down to the grandchildren. So 1/3 of 1/3 is 1/9. So right of representation is very important for you to be aware of, whether or not you die without a will or you die with a will that has right of representation in there. So as parents and grandparents, I would encourage you, decide if you want the right of representation to apply to your family. Is that the way you would do it? Well, you need to think about that. Now here's another flower that I have used in my meetings, and it's been kind of fun because you see the term there, toxic. And one of my participants shared with me that, well, she asked the question, do you know that larkspurs are very toxic? And I thought, isn't that great? We can talk about toxic family relationships that develop sometimes with the lack of estate planning. Now here is an example. We've got the bachelor brother there who has the red lightning bolt. Well, this bachelor brother has died. And you see he is survived by his mom and dad. He has sisters and brothers, and he has nieces and nephews. So the question becomes, well, of these groups, which one has priority? So take a look at that. Which relatives have priority under the Montana Uniform Probate Code? Would it be the parents, mom and dad? Would it be his brothers and sisters? Or would it be the nieces and nephews? Well, I hope you guessed mom and dad, because that is entirely right. Mom and dad have priority over siblings when it comes to inheriting this brother's estate. Now, the reason mom and dad have that priority is this gentleman was not married and he did not have any children. So let's take another example. Let's say that the bachelor brother died and dad was the only survivor. In that case, he would receive everything. Now, let's take a look, though, and see the same situation, but we've altered just one thing. And that one thing is that mom and dad have passed away. So what group has the priority next? Well, it's brothers and sisters. And because we have 4 brothers and sisters, it means that each of those receive 1/4 each. So we have 1/4 to the 2 sisters and 1/4 to the 2 brothers. But now we've got a different situation. What we've got is a sister that passed away in 2001, and she has a niece. We have another sister that passed away in 2005, and mom and dad are already gone. So when this bachelor brother passes away in the year 2011, I want to know from you, what fraction, if any, does the brother receive with the red lightning bolt? What fraction, if any? So your choices to guess, if you had a clicker, would be all, 1/2, 1/4, or nothing. Everything goes to Montana because he has not written a will, he does not have a surviving spouse nor a child. Well, I hope that you said 1/4. And the reason I'm hoping that you said 1/4 is that was a way to evaluate for myself how good a teacher was I in explaining the right of representation. Because you can see here that we are once again looking at bachelor brother dying. How many brothers and sisters does he have? 4. So that means we're going to divide that 1/4, 1/4, and 1/4. So in the case of the sister that died in 2001, it's the niece that receives 1/4. And it doesn't matter that the niece left the country, not really the country, but she left Montana and moved to New York City. And she really hasn't been back. She looks at all of her Montana relatives as a bunch of hicks. But guess what? She's back. And what do you think she wants? Money. And we also then see that the sister that passed away in 2005 had 2 children. So these 2 are going to split the 1/4 the mom would have received had she lived. Now, if we've got this as a downtown business, isn't that going to be very interesting to figure out who winds up running the business and doing those types of things? Same way with a farmer ranch. You know, we've got the daughter that's really wanting her money, and what if the 2 brothers cannot afford to buy her out, or maybe for some reason they can't get a loan to buy her out? So that could be one of those toxic family relationships. Now, if we had a situation with 3 siblings that survive, each one is still only going to receive 1/4 because we had a sister that died before the brother did. So we have that little interesting niece receiving the property. So again, that concept is called right of representation. Right of representation. Now, it could have been the bachelor brother could have written a will. And in his will, he could have left all of that property to his favorite nonprofit organization. And in this case, it may have been the Montana 4-H Foundation. So if you know of some singles, some people that aren't married, share this information with them, because they need to decide if they want to pass their property by right of representation, or do they want to take control and avoid an example like mine where there were toxic family relationships that resulted. Now, this particular flower is called a prickly poppy. And I've heard some people from eastern Montana say, oh, we've got those out our way. But this particular one is one that my husband took. And we have this game that we play, Best of Show. So my shot did not turn out that well, and that's why he has the honor of his being in my presentation. But what the prickly poppy makes me think about is how you title your real and personal property can be prickly, or the result can be prickly. So here's what I mean. Let's take a few examples here of looking at solely owned property, joint tenancy with right of survivorship property, and tenancy in common. Now, most of you have heard of joint tenancy with right of survivorship, but tenancy in common may be a little bit unusual for you. So what I want you to do is first take a look at your title documents, the deed, your checking account, your investments, and make sure that you know how your real property and personal property are titled. So that makes me think of something. These two pink monkey flowers make me think about joint tenancy between parents and children. I get asked this question a lot, where I've got parents that are wanting to transfer property to the kids, and they say, that's okay, isn't it? Well, let's take a look. Here I've got a mom, and that mom has $80,000 checking account with her daughter Susan. Okay, joint tenancy with right of survivorship. Sarah has 2 additional children. Now, what mom has done is written a will, and in that will, she is dividing that $80,000 among her 3 children. So my question for you is, how is that $80,000 divided? Is it going to be equally among Sarah's 3 daughters, as was required in the will? Was it all going to Susan as a surviving joint tenant, all to Carrie, all to Jane, or all to the state of Montana, because we've got situations where Montana receives the property? So take a look at those choices and see which one you would select. Well, I bet many of you said, well, it's going to be daughter Susie, because it's a joint tenancy. But I may have had some others saying, no, a will overturns everything. It's the highest priority. And I would say the answer in this case is no, because we had that joint tenancy, and the joint tenancy is a contract. So Susan gets it all. Now, do you think Susan is going to share with Carrie and Jane? You'll have to decide what you think about that, and particularly if it was in your family. So here's the dilemma. We know that joint tenancy property with right of survivorship on real and personal property takes priority over a will. And it doesn't matter if the will was written before the joint tenancy was formed or after the joint tenancy, because once you've done a joint tenancy, that is the challenge. So what do? Well, let's take a look at something that the Montana legislature has provided for us. And that tool is the Multiple Party Account Act form. And it allows you to make an agency designation on your savings, checking accounts, etc. So that allows that person that you name to make account transactions, but they don't have any ownership right in your checking account. So there's a box there, and you would mark the box that you want to have. Now the top line is Multiple Party Account Act, well, not Act, but with right of survivorship. And then the other one is without right of survivorship. And on the form, it tells you, at death of party, the deceased ownership passes as a part of the deceased owner's estate. So what that would mean is, in our estate here of Sarah, if she checked multiple party account, then what's going to happen is when she dies, the property goes equally to the 3 daughters. But while she's alive, she still can have daughter Susan do the checking account, savings accounts, write those checks for some of her bills. So that is a good thing I think our legislature has provided. Now this information is available to you in MSU Extension's mock guide entitled Non-Probate Transfers. It also provides a sample of the Uniform Party or Multiple Party Account Act form. So you can take a look at that in the mock guide. So my reflection from the pink monkey flowers is utilize the Montana Multiple Party Accounts Act form when appropriate. So you first got to make the decision, and then you've got to check with your financial institution to see what kind of form they have. So that's my pink monkey flower reflection. Now here we have some white mule's ear. And what that makes me think about is Dad being stubborn as a mule. Now, I don't know if that would be true about your dad, but I gotta admit there were times when my dad was just as stubborn as a mule. So what we've got is a situation where we've got a dad and the sons, and he has remarried because his first spouse died. So what he's done is placed the property in joint tenancy with his new wife. Now, we've got a problem here because what Dad has done is written a will, and that will was written after the joint tenancy is formed. So Dad is saying, hey kids, get off my back, because one of these kids had called me at the office and said, we want you to explain joint tenancy to our dad. And I explained that, invite him to one of our estate planning meetings, but I can't serve as an attorney for him. But anyway, what we're looking at is Dad dies. Will the kids get the ranch? And the answer is for you to think yes or no. Well, I bet the majority of you said no. You see, that joint tenancy contract takes priority over the will. So that means the new wife here receives all. And that really wasn't what Dad had in mind. He wanted some of that to go to his two kids. But technically, he disinherited his kids by putting that property in joint tenancy with his wife, because it always goes then to that surviving joint tenant in this situation that I've described here. Now let's go forward a few years. Let's say that several years later, the new wife dies with all the property in her name. Now, who is going to inherit that property? Well, you probably guessed it. It's her children. So what we've got is a dad that disinherited his kids unintentionally, and we've got the wife, or in this case, the mother there of those two turquoise children, receiving 50% apiece. So this is not the time for do-it-yourself estate planning. Dad should have done some further work with the attorney to assure that what he wanted to have happen would indeed happen. Now, I know of another situation similar to this, where the new wife remarried. Well, would you believe she placed the property in joint tenancy with right of survivorship with her new husband? Then the wife died. Who received all that property? Who received it all? The new husband, of course. So you see, by her placing that property in joint tenancy with him, she has disinherited her kids. And he had disinherited his kids. So we don't want to do that, I don't think, in most family situations. They want to provide at least something for the children. But in this case, 0 is what they would receive. So don't be as stubborn as a mule. Let me encourage you to seek legal advice before you're titling your property, especially in a case of remarriage. You just really need to know about that. Okay, the other thing is to consider a premarital agreement before you remarry. Yeah, this is a really good idea. And in extension, we have a document. It's called a Monk Guide, which is a fact sheet that discusses some of these financial issues. And believe me, if you can't talk about it before you get married, you need to do that. So that's what we need to do. Now here we have two beautiful flowers that are among my favorite. We have an albino fairy slipper, And this is one that I found in Yellowstone National Park. And I also have a regular fairy slipper. And so that reminds me of John and Mary Albino. And they had told friends and relatives that they wished to leave their property to the MSU Alumni Foundation. That was their goal. Now, in this case, they're what I call my traditional Montana family, in the sense that all of the property is in John's name. Now, let's say that they have an automobile accident. John dies first. Mary dies 3 days later. They don't have a will, and they do not have children. So the question becomes, who's going to receive this property that's in John's name? Remember, John dies immediately. Mary dies 3 days later. So who receives the property? So you get to click one of these in your mind. Okay, the answer is John's relatives. But it's not necessarily for the reason you think. What happens is we have in Montana a survival requirement. And that survival requirement says an heir must survive by how many days? Well, 120 hours is 5 days. Otherwise, we've got the heir as being treated as predeceasing the decedent. So in this case, Mary is treated as predeceasing John. Now, I don't know the logic there, but that's what's in our Uniform Probate Code. So many of you may have thought it would be obviously Mary receiving the property, but her relatives, but because she lasted the longest. But in this case, it wasn't quite long enough. So since I hadn't yet convinced this couple to write a will, I said, John, let's take this one step further. Let's say you die immediately, but Mary doesn't die until the 6th, 7th, or 8th day. It can be any of those times. And what happens then is, of course, because Mary has survived beyond that 120-hour rule, she is now eligible to, feel sad, I guess, because in this case, she's gone, but it's her relatives that receive the property. It's Mary's relatives. So what I found is that John and Mary were very eager to go ahead and get their will written. And in this case, they made an appointment with the attorney to write a will. And they want to leave it to the Montana State University Alumni Foundation. So, here's the point. You cannot verbally do a will in Montana. We may have some states that are headed in that direction, but not in Montana. Now, there's some attorneys that have videotaped or recorded a person signing a will, but that is to help to make sure that if there is any kind of will contestment, it's very clear that person was of sound mind. So my reflection from the albino fairy slipper is that married couples that have solely owned property must write a will that will control what nonprofit, what family receives their property when they both pass away. Now, this is a heart-leafed arnica. And that reminds me of some heart-to-heart estate planning that Joe Hart and Brooke Hart were doing. Joe has heartfelt intentions. He's going to have this $100,000 life insurance policy, and he's designated Brooke, his sweetheart, as his primary beneficiary. Well, later, Joe has changed his mind. He's changed his heartfelt intention, and he writes a will, and he says, I bequeathed all life insurance proceeds to my son, Eric Hart. So we've got Joe changing his mind. He doesn't want Brooke, to receive that money. He wants it to go to his son from this life insurance. So who gets that $100,000? Is it going to be Brooke because she is the designated beneficiary, or is it Eric because he's the devotee in a will that was written most recently? Well, surprise, surprise, the $100,000 life insurance proceeds go directly to Brooke. Why? She is considered as the designated beneficiary on the form, and the form is a contract. The form is a contract. Important thing to know. Now, what should Joe do if he wants to change his beneficiaries? It's really very simple. All he's got to do is fill out a new beneficiary designation form and send that to his life insurance company. But the other thing, he should also keep a copy for himself, for his own records. Now, at my meetings, I actually have people read this out loud. And I know some of you may be watching this in the library or some other place. Maybe your family is looking at their favorite TV show and you're at the computer trying to do this. My suggestion would be read this out loud. You can't undo a contract with a will. You can't undo a contract with a will. And you see that life insurance beneficiary was a contract. So he could not leave a will and leave this out. So have a heart. Review your beneficiary designations and on your life insurance policies and also your individual retirement accounts. Those are accounts people often forget about. You know, you maybe are getting several different funds that you're in, but it's very important that you sit down and review those beneficiary designations. Now, this particular flower is called a death camas, and you can imagine my embarrassment at being at a sort of a mini retreat, and I would ask the audience, what flower is this? And then I tell them it's the death camas, and wow, this is the card I had sent when I didn't know the name to a friend's mom that was seriously ill. But luckily, she came out. That means what I can do is give you, there we go. We have Montana Estate Planning Tools, and these are called PODS and TODS. Well, what they stand for is, the first one is a payable on death designation. And these are your accounts at your financial institutions, your banks, your savings banks, your credit unions. And you can put a POD on your savings accounts, your checking accounts, certificates of deposit, and even United States savings bonds. Now the thing is, because you have a payable on death, the ownership passes to the POD beneficiaries. There is no probate of that asset. All you need is an affidavit of death, which is something that we have available at our website, and a government-issued photo ID. Okay? Now, let's look at a couple that has a joint tenancy. This is Barb and Jack. And Barb and Jack have joint tenancy with right of survivorship. And they think because they have this, they don't need to have a POD. But I reminded them, you travel a lot together. And what if you were killed together in a plane crash? What if you died together in an automobile accident? Isn't this awful, all the things I have people happen to them? But you see, Barb and Jack could do a POD to their two children, Charles and Kathy. That's POD to those two, and then they receive it with taking that affidavit to the financial institution. Now, a TOD is a registration, instead of designation, they call it a registration, and that's for transfer on death. This includes your publicly traded stocks, bonds, and mutual funds. Now, your TOD beneficiary is the one that's going to make the decision about the mutual funds, stocks, bonds. Are they going to keep those, or are they going to sell those? And that's something you would have to think about. If you were left a bunch of stocks and bonds, you're going to keep them or sell them. Now, if you keep them, let's say I have $1 that I paid for some stock years and years ago, and now it's gone up to $1 million. Well, if I inherit that, I assume that 100 or that $1 million value. I assume that that's the fair market value at the date of death, and that's where you start all over. But you see, if the person decided to sell the stock, it started out at $1, and let's say I just gave it to a nephew. Well, if I gave that to a nephew, that means he assumes my dollar basis in that particular stock or mutual fund. And that could be a big, big capital gain and resulting increase in taxes. For the first time, you can also POD or TOD to a charity or nonprofit. And just a couple examples of those would be the Montana Community Foundation, the MSU Alumni Foundation, and the Montana-4-H Foundation. Okay, so now for the first time ever, we can do PODs to charity. If we don't have children, we don't have somebody that we want to receive that, think about that as an alternative. So use PODs and TODs to control property distribution and avoid probate fees at death. Now, this is one of my favorite flowers as well. I suppose I'm saying that about all of them. But this one is called a explorer's or an explorer's gentian. And it's a very beautiful blue that shows up in August in a lot of the national forests. It's not available out very soon like that. So our explorer's gentian tells me, let's explore a beneficiary deed. Now, a beneficiary deed is a way that you're going to leave your real property to what we call one or more grantee beneficiaries. And you're doing this upon death without the cost of probate. So you could use a beneficiary deed for a $50,000 home at Bozeman. Chances are it's more likely to be $250,000 or even $300,000. Okay, so what we've got then is the grantee receiving it, but there's no ownership rights. It's only effective upon death of the owner. You cannot use this for collateral. You can't sell it. And the beneficiary, the grantee, is not the owner. Where do you record your beneficiary deed? That would be with the clerk and recorder in the Montana county where the property is located. So it's the clerk and recorder where the property is located. Now, who can be your grantee beneficiaries? That can be your spouse, your children, maybe you've got some close relatives, friends, even a corporation. And how about our charities? You could list charitable organizations or some nonprofits. For example, the Montana Alzheimer Association. And I encourage you to be very clear. If you want it to go to Montana's version and not the national version, you need to be clear in that. Because we've got a case going on right now in Butte where, this group thought they had a lot more money than they actually did. Well, what had happened is sort of lack of communication there. Now let's take a look at a foxglove. That reminds me of what should you do if the grantee beneficiary dies before the owner. I want you to outfox the law. And how do you do that? You can be foxy and specify a successor beneficiary. So that's what Mark Fox has done. Mark has said, if I die, I want the property to go down to Evan Fox, my son. But if Evan Fox dies with me or before me, I want it to go to Luke, who is my grandson. Or, my goodness, you could even select a nonprofit as a successor for your beneficiary deed. So my reflection for the foxglove is outfox the law and name a successor grantee beneficiary. Now here we have a blue flax. That reminds me of Gary Blue and his 2 blue children. So we've got Gary Blue and Linda Blue and Matt Blue. And what Gary has done is filed a beneficiary deed. And in that deed, he has named his daughter, Linda Blue, as the grantee beneficiary. Well then, several years later, Gary wrote a will leaving the same property to his son. So the son was named in the will. Linda was named in the beneficiary deed as a grantee beneficiary. And we need to know who is going to receive that property when Gary Blue passes away. Is it going to be Linda, the grantee beneficiary, or is it going to be Matt Blue? Because remember, he was named in the will then, and the will was written after the filing of the beneficiary deed. So who gets that property when Gary Blue passes away? Well, I hope you said Linda. You see, what we've got here is another example of what we would roughly call a contract. It's a deed, and you're saying you want this person to get it upon your death. And so that is going to override the will. And it really doesn't matter if that will was written earlier or later than the beneficiary deed. So we've got a situation here. Matt is singing the blues. And can you imagine Thanksgiving in this family? I dare say probably both of them wouldn't show up in the same room because Matt's saying, well, it's obvious Dad wanted me to have it because he wrote the will. And Linda's saying, well, it seems to me he wanted me to have it first. So I don't think there would be a bunch of enjoyment there. So you can't undo a beneficiary deed with a will. And it doesn't matter when that will was written, whether it was earlier or later than the filing of the beneficiary deed. Well, my observation from my lady slipper is said that time has really slipped by. And it's gone a lot faster because I didn't have questions from an audience like I'm used to. So if you had questions, and I should have said this in the beginning, my apologize, but you are welcome to send me an email. My address is getting, GOETTING, @montana.edu. And we've got some resources that you would be able to utilize. But I do hope I steered you towards an awareness of Montana's plan for the transfer of your property. And ownership issues are the key there because how you've titled that property determines who's going to receive it upon your death, and that you cannot will away your share of joint tenancy property because it's a contract, and as a contract, it goes to the surviving joint tenant. I also hope I steered you to a variety of estate planning tools. And these are tools that we talked about: the payable on death designation, the transfer on death registration, and a beneficiary deed. All of these allow for assets to transfer to the next generation without probate. And since the probate fees of an attorney and the personal representative are based on what goes through probate, then that saves the estate and the kids that are going to inherit it considerable money. Now, if you don't have a memory like this elephant's head, yes, that's the true name of this particular flower. And if you notice, look at the ears and look at the trunk. It's a very fun flower to find. But we have, through our estate planning website, 40 different monk guides in the area of estate planning. So just go to the website, click on estate planning publications, and a whole list with a short description is included. And don't forget, that's the name of these flowers. These monk guides are also available from your local MSU county extension agent. So go to the county office, or you can give that office a call as well and request the publications or the monk guides that we have. So that's what I've got for you for this part of your class. As standard, you will have a test to take on this particular topic, and I encourage you, if you don't know the answers, you are certainly welcome to review the video and see if you can find those answers. But again, there's my address at the bottom of the page. If you have a question, don't hesitate to email me. But I will say I travel a lot in my job with Extension, and oftentimes I'm gone for a week or two at a time. And when I have my Wi-Fi available in a community, I like to take care of my emails, but sometimes it just doesn't work. So may I wish you luck in best wishes as you start looking at doing your estate planning. And of course, once you've got it done, you can then tell other people, hey, I've got peace of mind because I've done estate planning or legacy planning for my family. Thank you.